Transcript of Proceedings, Tennessee Board of Law Examiners. Date, December 3rd, 2018. Case, in re, Charles Van Morgan, docket number 18-05. MR, Ward, okay. Mr. Graham, Mr. Morgan, welcome. I'm Jeff Ward. I'm the current president of Tennessee Board of Law Examiners. You have got the majority of the board in front of you today. On my far right is Mook Barker. To my immediate right is Barbara Zuckala. To my far left is Margaret Bem. Our proceedings are primarily informal. The one formality that we do have is that anyone that's going to be giving testimony, we ask that you be sworn in. So what I'll do is, I'll state our docket number. This is in the matter of Charles Van Morgan, docket number 18-05. And if you'll swear in Mr. Morgan for us. Charles Van Morgan was sworn. MR, Ward, Mr. Morgan, you have seen the show cause order, and we have received your response to that. Typically, what we do is turn it over to you and your attorney to present information that you think the board needs to hear in order to make a determination as to issues in front of us related to your application, and then as you present information, we may have questions as it goes along. As we get started, Mr. Graham, do you have a number of other witnesses? MR, Graham, I have one, sir. MR, Ward, one other. Okay, who will that be? MR, Graham, that is Mr. David Leverett. He is a former supervisor of Mr. Van Morgan. MR, Ward, his last name again is? MR, Graham, Leverett, Leverett. MR, Ward, is that one of the ones that we have an affidavit from? MR, Graham, no, you do not, because he's appearing. MR, Ward, okay, and I will turn it over to you to present. MR, Graham, thank you very much, sir. Board members, I am David Graham, as you know, and I represent Mr. Van Morgan here today. We have a case that I have spent a lot of time on, and I think we will adequately address the concerns that you have raised. We take them very seriously. We do appreciate the opportunity to speak with you about this today. Before I tell you about what our case is, I want to tell you about what our case is not. We are not here today to call into question the findings of the system in the Tennessee Highway Patrol. We are not here to second-guess the findings of fact that they relied upon in reaching their decisions. MR, Barker, can you speak just a little bit louder? MR, Graham, I'm sorry. We are not calling into question the findings of the Chancery Court or the Court of Appeals. We're not here to do those things. However, I do not believe that we can adequately address the concerns that this board has raised without making at least some reference to those materials, and so I ask for your patience in that regard. I'm here today to show you that Mr. Morgan's law enforcement career spanned 18 years, and that the isolated acts of November 26, 2011 do not define his character of service. We intend to show through the testimony of his supervisors and an extensive collection of documents that his career was actually a model of honest and orderly public service to the system in our state. And I'm going to ask you to apply a balancing test to compare whether the isolated acts of one night are a fair judgment of a man who spent otherwise 18 years of honorable service before the state. Mr. Morgan, you'll hear from him shortly. He is going to explain to you his answer to question 20 on the NSB. You will find what he tells you is, he will acknowledge that while his response was admittedly insufficient, it was not designed to mislead this court. And last, he will tell you about actions that he has taken to correct the record with respect to that matter. I intend to show today that this applicant is fully committed to that conforming behavior as an attorney, and to that end, he has voluntarily sought and attended training with the University of Tennessee regarding ethical behavior. He has completed that study, and he has earned the confidence and the recommendation of his professor, who will testify through affidavit in a moment. And lastly, what I want to show you is, I want to argue that Mr. Van Morgan is not prone to lawsuits. If he is, in the alternative, it's only because he was a highly productive police officer. He made a lot of arrests. I am going to ask you to buy into my admittedly anecdotal argument that a busy officer is much more likely to be sued than one who is not. Against that evidence, I am going to ask you to acknowledge that even though there only were 4 lawsuits, they were over 18 years, and they stemmed only from 3 cases. And in each instance, the date of the applicant. MR, Barker, I'm just really having a hard time hearing you. Maybe it's this fan. MR, Graham, I'm so sorry. Where did I lose you? I'll start over. MR, Barker, just about 3 minutes ago. MR, Graham, okay. Well, the last topic I was talking about was what his lawsuits were. MR, Barker, I hear you now. MR, Graham, yes, sir. As the board knows, Mr. Van Morgan was sued 4 times over an 18-year career as a law enforcement officer. What I'm going to show is, through the evidence we're going to present today, he was one of the most productive officers of the Tennessee Highway Patrol. And against that evidence, I'm going to ask you to buy into my anecdotal argument that because he was so active, he was more likely to get sued than an officer who did very little. I am also going to ask you to consider the fact that in no case were those actions successful and that Mr. Van Morgan was not held liable for any of those acts. At this time, I'm prepared to bring some evidence before you. I would like to start with the direct examination of David Leverett. He is waiting outside. MR, Barker, you have to be your own bailiff, Mr. Morgan. MR, Morgan, okay, that's fine. MR, Graham, I'm sorry, folks, I'm sick. If I'm not loud enough, tell me. MR, Barker, we kept you waiting all day. We're sorry. MR, Graham, that's all right. We're glad to do it. Thank you for having us. MR, Ward, if it helps you to bring that table forward some so you're not having to. MR, Ward, that's entirely your decision, sir. If you want me to do it, I will. MR, Ward, if we can have you sworn in first, then you can start asking him questions. David Leverett testimony. David Leverett was sworn. Questions by Mr. Graham. Q, would you please state your name and address, sir? A, David Leverett, 525, County Road 280, Neota, Tennessee, 3826. Q, Mr. Leverett, are you employed? A, I am retired from the University of Tennessee Medical Center as a police officer and served as a supervisor. Q. Mr. Leverett, how do you know the applicant, Mr. Van Morgan? A. I know Mr. Morgan because when I went to work at the University of Tennessee, Mr. Morgan was working there as an officer, and then later I became his supervisor at UT. Q. And what were those dates, sir? A. Those dates were around 1998 to 2008. Q. And during that time, were you able to evaluate his performance as a police officer? A. Yes, sir, I was able to do that. Q. What, if anything, can you recall about that performance? A. What I recall about Mr. Morgan is he was always punctual. He did his reports on time. He did a thorough job. Mr. Morgan was black and white. What I mean by that is, it's either right or it's wrong. And he always focused on doing the right thing. He did a good job. And he followed through on everything that he was doing appropriately. I could count on him, and so could the department. Q. Mr. Leverett, did you form any opinion as to his propensity for ethical behavior, for honesty and integrity? A. Yes, sir, I did. Q. Could you please share those thoughts with us? A. Through my time knowing Mr. Morgan, what it's been the business relationship working in law enforcement, and through the years, even after he worked Tennessee Highway Patrol, we talked through the years. There would be times that he might bring somebody in for a blood alcohol kit or what have you, and through the years, our conversation has been of a professional nature, but it's always been a fact that in those conversations, I know he strived to always do the right thing and strived for excellence as he worked as a state trooper. Mr. Graham, board members, I have no further questions. If you have any questions for Mr. Leverett, I would be happy to respond. Mr. Ward, okay. Any questions? Questions by Ms. Bem. Q. What period of time are you talking about when he was there? A. He was there from 1998 until around 2002. Q. That's good. And since then, have you had interactions with him? A. Yes, ma'am. There have been a few times that we have talked. I was very familiar with him, and we talked on and off. As I said, when he was a trooper, he would bring someone in for blood alcohol, or he worked nights. I worked a lot of nights. It might be that we would communicate. I would call him asking him about specific information that I might need, or if there might have been an accident I needed information on that he would assist me with. We have talked other times of a personal nature, which would have to do with the fact of we talked about where he was going to church one time. We talked about that. And Q. Since 2002, how often have you interacted with him? I mean, on an annual basis. A. We probably have talked 2 or 3 times a year. Ms. Bem, thank you. The witness. Yes, ma'am. Mr. Ward, Mr. Leverett, we appreciate you being here. Thank you very much. The witness. Yes, sir. Thank you so much. Charles Van Morgan testimony. Mr. Graham. Sir, I call Charles Van Morgan. Mr. Ward, you can sit right there, sir. Go right ahead and ask him questions. Charles Van Morgan testified. Questions by Mr. Graham. Q. Mr. Van Morgan, I would like to begin by discussing your career as a police officer. Can you briefly tell the board where and for how long you were so employed? A. Yes. I was employed as a police officer for approximately 18 years. I started with the Nueces County Sheriff's Department working in the jail and corrections. And that is where my sister lived. That's why I was out in Texas. And I got a job with the University of Tennessee Police Department and the campus, and then went to work for the University of Tennessee Hospital Police Department, where I met Mr. David Leverett, who served as my immediate supervisor and was lieutenant at the police department. And then in 2002, November, I went to work for the Tennessee Highway Patrol for approximately 10 years. And the last I was employed as a police officer is in February of 2012. Q. Mr. Van Morgan, I'm showing you items I've marked as Exhibits 1 through 32. Would you please describe these to the board? A. These are the list of awards and accommodations that I received over the course of my career, at least most of them. Q. Mr. Van Morgan, would you find Exhibit 8, please, and describe that to the court? A. Sure. This is a commendation letter from the University of Tennessee Hospital Police Department from Lieutenant Gary Davis. And he is writing a letter to the chief over the UT Police Department telling him that I should be accommodated for coming in when I was off duty and helping out with the disaster, working above and beyond my normal duties, and thanking me for that. Q. Thank you, Mr. Morgan. Exhibit 14, please. We don't have all the copies of these. I think you would like to hear about them. 14, please. A. This is a letter from the Tennessee Highway Patrol. It is a memorandum addressed to me from Captain Raymond Fletcher. He has initialed it here. It is a thank you letter for leading the district in drunk driving arrests and asking me to continue doing that and thanking me for my hard work. And it's dated November 2006, one of many that I received. Q. Thank you, Mr. Morgan. Exhibit 17, please. A. Exhibit 17 is an award from an outside organization, the Optimist Club of Knoxville. And I was recommended for that award from the Tennessee Highway Patrol, my immediate supervisors, and Captain Ray Fletcher. And it is the Optimist Club Trooper of the Year. And it was in May of 2007. Q. Thank you. Mr. Morgan, Exhibit 28, please. A. This is an award from the Tennessee Highway Patrol, Top DUI Enforcer, first quarter of my last year of service 2011, when I made in the first quarter 27 DUI arrests, and it is signed by Colonel Tracy Trott. Q. Mr. Morgan, Exhibit 30, please. A. This is the second quarter of 2011, the last year I worked, Top DUI Enforcer from the State Highway Patrol recognizing me for 30 drunk driving arrests, signed by Colonel Tracy Trott for the second quarter. Q. Mr. Morgan, lastly, Exhibit 31, please. A, this is a letter from Lieutenant. From Colonel Tracy Trott of the Highway Patrol informing me that impaired driving causes too many tragedies in our state and recognizing that he had made that a priority and thanking me for enforcing the DUI laws and recognizing me as leading in the district of 27 arrests in Knoxville, thanking me for my hard work and dedication, and also urging me to remain diligent in those enforcement activities, signed by Colonel Tracy Trott. Q, Mr. Morgan, have you seen all 32 of those exhibits? A, yes, I have. Q, are they all genuine? A, yes, they are. Mr. Graham, thank you. May I have them, please? Board members, I would tender to you Exhibits 1 through 32 for your consideration. Mr. Ward, can our court reporter mark that? Exhibits numbers 1 through 32 were received into evidence. Mr. Graham, thank you. By Mr. Graham. Q, let's move to your response to question 20 of the NCB background investigation. You answered no, is that correct? A, yes, I did. Q, would you please explain to the board why you answered that? A, first of all, let's say, obviously, that was incorrect. I apologize for that. That was a mistake. The reason that I put no was because in my mind I had already listed that in the NCB application. And the question asked about being the subject of an administrative hearing for dishonesty and other, and I took it to mean that had the administrative agency initiated that against me. And since I was the one that initiated the action in contesting my termination, I didn't see it correctly as something that I needed to put yes on that. Obviously, that was incorrect. There was no attempt to deceive or be dishonest on my part, since I had included it, although I recognized that that wasn't adequate, and I apologize for that. And I have taken measures to mitigate that by my immediately, upon notification of my error, sending every one of those cases into the NCB. Q, Mr. Morgan, you had repeatedly described your termination from the Tennessee Highway Patrol as, I quote, wrongfully terminated. Appeal pending in the Tennessee Appeals Court. Can you please explain to this board why you have not been more specific in disclosing with respect to this issue? A, okay. I did disclose it in the initial application and put that on my application to the Nashville School of Law and was accepted into law school after disclosing it, and I did not update them. I didn't know that I was supposed to update them after every court hearing. And the case was still in fact pending after my graduation. There hadn't been a final result, as there has been now. But I should have done a better job in letting them know after every hearing. At the time, I didn't do that, but I certainly didn't intend to be deceptive. I did notify several of the professors of the ongoing situation with emails, and the same professors that I emailed the circumstances of the case, I asked the same professors also to mail in references, and they mailed in references to the NCB in fact knowing about that. But I do recognize that I should have updated them after every case. I didn't know that I was supposed to do that. Q, Mr. Van Morgan, what assurances can you offer this board that should they grant you a license to practice law, you would be so honest that you will respect the rights of others and obey the Constitution and the laws of our state? A, well, I served 18 years as a road police officer, and I tried to do my best to protect people's safety and a lot of times risked my life. I've seen a lot of bad things, and I have always strived to do the best that I could to improve things. That's why I made a lot of drunk driving arrests, to try to protect people from getting themselves killed and other people. And I also have references from supervisors who knew me, supervised me every day, that I am very honored that they think enough of me to recommend me to the board. And they know me and they know the job that I can do. I recognize that there are some things on my past, specifically the litigation where I lost my job. And I appreciate the board giving me the opportunity to explain that. I agree that I have to abide by the rule of law and accept that. I lost my job and me and my wife lost our health care and I have moved on. I have in fact taken the class in professional responsibility, as I know that everyone, even myself included, especially with the Highway Patrol, can improve. And I spent several months over the summer taking that class from an ethics professor at UT. Just last Friday, I took an ethics class in criminal law with Banks and Jones that has been approved for credit for in-service for attorneys. And I took that class trying to learn more about being an ethical attorney in criminal law, which is combined with my law degree and my master's degree in criminology from the University of Tennessee. I intend to, if I am able, and I respect your decision, although I'm trying to influence it, then I will try to use that knowledge to help people, because I think I have a better understanding to apply to the poor and underprivileged than a lot of people do because of my education. Mr. Graham. Board members, I have no further questions for Mr. Van Morgan. If you have questions, I would like to hear them at this time. MS Bam, I can start. Questions by Mr. Barker. Q, I guess I am, like I suspect other members of the board are, interested in the facts of this fiery crash and the chase and all that ensued. As I understand it, from what the Court of Appeals found, that you did not come forward truthfully when you said you didn't see the red car. They found that you did. Tell us just what happened. A, I appreciate that question. I obviously disagree with the courts. I appealed it all the way, and I testified honestly under oath about those circumstances. The courts disagree with me about the incident. Is that okay? The incident was when I was on Emory Road. Q, in Claiborne County? A, no, in Knox County. We were asked specifically to patrol that road for speeders. And I was on Emory Road, and I witnessed a car speeding at a high rate of speed, moving radar on my front antenna, and immediately turned on my emergency equipment and turned around and pursued the car. I do have a letter here from the captain of the Highway Patrol at the time, Captain Sanders, saying that I did follow the Tennessee Highway Patrol pursuit policy. And that's what I was trying to do. I called in a pursuit, gave my charges, direction of travel. I am doing the best I can, and you have to understand. I'm talking about it here, but if you understand, this is out on the road where you don't know who you're pursuing, and it's a highly stressful situation. Q, you said something in here about it being you were pursuing a fleeing felon. I thought all you knew is he was speeding. How did you conclude that he was a felon? A, at the point that he eluded the stop that night is a felony. So if he is just a speeder and stops, then he is a person that's guilty of speeding and can be cited or released. But if you are in pursuit of a speeder, from my understanding, when they attempt to elude you, eluding a lawful officer, it is a felony. So at that point that he attempted to elude me, he was a felon. That's why that is that statement. And the discretion about whether to pursue is left to the officer on the street subject to a supervisor. That's why you call it in. And there's several conditions, and I knew the pursuit policy well. It's obviously a highly dangerous circumstance. I had it right above my visor. And they're like the road condition, the other traffic on the road. And you consider all those things without going into pursuit. This was 3 o'clock in the morning, so there wasn't a lot of traffic out. There wasn't a major hazard to other people. The supervisor knew and did not terminate the pursuit, which I would have terminated it if he ordered me to. And he went through a green light. And I had to slow down because it was a red light. And the Vanessa Free-Cade Act is the act that controls law enforcement's response to driving in an emergency, and that was a case where Vanessa Free-Cade was killed by a Chattanooga police officer that ran a red light, I believe, and killed her. And that law, his family got that. And it requires 1 year of in-service training. And I slowed down for the red light. I only almost came to a complete stop so as not to endanger other traffic. And nothing I did that night endangered anyone. And I didn't wreck, didn't hit anybody. I was responsible for myself. And the intoxicated driver got a pretty good lead on me when I had to slow down. And he turned off the road. And at night, when you're pursuing a car, it's different than in the daytime. You actually have to find the road that they turn off of. It's the best I can explain it. It is not like TV, it's the real thing. And I had turned on. He turned off of the road and I turned on the road. I lost sight of him several times. And each time I am pursuing taillights. You see a dot in front of you. I've done this a lot of times when you're catching, trying to apprehend a speeder. And I was, at the minimum, I hadn't even been able to get close enough to get a license plate yet, because if you can get a license plate, you can terminate the pursuit and go to their house, because sometimes it will give you their address. I hadn't got that close yet. And he topped a hill, and I lost sight of him. And I came over the hill, and I was looking down the road where he had been, and I caught a car off the side of my corner of my eye, and even considered. I said, "Is that it? Is that it?" I thought, no, it can't be, because at that time, in the dark, it was off the road. It appeared like a parked car. The damage was on the front of the car. And I, in a glance of a second, I saw, the urgency of trying to keep up with him, trying to keep up with the car, at least get a license plate. And there's also the general order, the 15 to 30 second rule. I hope I'm not going too far into detail. The 15 to 30 second rule that I was following was that you can continue to pursue a car if you lose sight of it, but you have to see the car within. 30 second is the limit. If you don't see the car within 30 seconds, then you have to terminate the pursuit. The idea behind that is that they don't want a trooper running around blind when he can't even find the person he is trying to pursue. So as long as you can see him within 30 seconds, you can continue to pursue him. When I topped the hill and didn't see him, and the road forks and I slowed down, and I dismissed that car as not being the car I was trying to pursue. I had no reason. I was trying to find him. And thinking about the 15 to 30 second rule, I've got to find this car or terminate the pursuit. So I gun it, guessing left, my best guess. And I didn't see him, so I'm thinking the time is running out on the 15 to 30 second. I'm going to be in violation of policy. So I needed to terminate the pursuit. I terminated the pursuit. This letter here that I says that I followed the policy in terminating the pursuit. I let my camera run for a minute. That's designed for liability purposes, that you are no longer in a pursuit if they keep going down the road and hit 3 or 4 people. And unfortunately, that was horrific. And what happened is, as I was sitting there, I'm thinking, did I miss something? I didn't see him down the road, and I remembered seeing that car. And I don't know, I'm thinking, have I missed something? And I think, well, maybe, that car, I didn't know, but I have to let my camera run out. And then they dispatched me back to the wreck. And that's the first that I seen and identified that car as the car that was the one I was pursuing. And obviously, that was a horrific incident. It was horrible. It is similar to something that you would see in a war. It's something that people shouldn't have to see, and unfortunately, it happens all too often. People get killed. And the Highway Patrol Policy, the Wreck Investigation Manual, and I'm trying to follow the rules, honestly, I am, says that upon a fire car wreck, you call the fire department. And it gives no further instructions about anything else that you have to do. And I called the fire department. And I got out of the car and approached it, and I sprayed the car, emptied the fire extinguisher the best I could. They say that I didn't name the fire extinguisher right, and maybe I didn't. I didn't have a lot of experience in firefighting. I was honestly trying to do the best I could, concerned about the explosion of the car and getting killed myself. And the man in the car, and it is hard to talk about it, he appeared to me to be dead. And I would have gotten him out of the car, but he hit a tree head-on at about 90 miles an hour, and obviously, that's something I didn't want to happen. I was trying to save his life to get him stopped. And it crunched him in the car, and I couldn't get him out. He was pinned. There was no way I could do that. And me and a bystander were within a few feet of the car trying to get him out. And the fire department arrived. I did say later, and it is in the pursuit policy, that you are supposed to be aware of liability issues involving pursuits. And obviously wrong, I was reported later saying that I didn't see the car. And that has never changed. I didn't see it and identify it as the car I was pursuing. But I did say that I was trying to put on a show, and that was an after-the-fact thing, that if you were in a situation like that as a law enforcement officer, when bad things happen, from my perspective and from training, you have to show that you're doing the best that you can do for liability purposes. And obviously, that was wrong. I shouldn't have said that. But there was no ill intent or ill will towards the family or anything like that. And it was taken completely out of context. I did try to save the life of that young man. I don't know if that answers your question. Maybe it was too detailed, but that's what happened. MS Bam, I have a question. Questions by Ms. Bam. Hugh, so you mentioned that you would be able to address the two different statements that we have from Larry French. And when I compare them, they look significantly different. Mr. French seems to back off some of his assertions about honesty. But his last paragraph seems to kind of go back to saying the things that they would be a misrepresentation of the truth. So could you explain why Mr. French needed, how we got the first statement from Mr. French, and how it came that you needed to get another statement from him? Mr. Graham, ma'am, before, and Mr. Van Morgan will certainly speak to that question, but I think there's a certain amount of background information. Ms. Bam, yes, whatever you want to provide. Mr. Graham, that statement was prepared prior to the time that I came to represent Mr. Van Morgan. When I interviewed Mr. French and I learned that he could not attend today's hearing because he goes to work, I asked if he would submit an affidavit. I had read that statement that you had right there. I wasn't comfortable with the format and didn't like the fact it wasn't notarized, that sort of thing. And so I prepared an affidavit. When I sent it to him, he wasn't comfortable with some of the material that was in there, so I prepared an affidavit that he was comfortable with. And from there, I'll allow Mr. Van Morgan to continue. Mr. Van Morgan, well, Ms. Bam, how did we get the first statement? Is that something you drafted and he signed? Or how did it come about? Mr. Van Morgan, yes, that is correct. When I received the letter from the board, I went through what was in the report, and I contacted the supervisors. I contacted Lieutenant Larry French, who is a very honorable man, and he is a veteran of the military and a highly respectful person. And I'm trying to be impressive with a respectable person. And included in with the letter to him, the email to him, asking him to give me a reference, and included the accusations, understandably, with that, exactly what you all have given me. Ms. Bam, right? Mr. Van Morgan, and he asked me back to, he said he would be glad to send me a letter of recommendation. He asked me to send him a sample letter, and I said, okay. I will. And I wrote out a sample letter, typed a sample letter with blanks in it. And he emailed me back and said that he had changed very little and signed it and put it in the mail. And that's how that came about. My assumption of it is, if you want me to, is it all right if my assumption of it is that he signed that letter in as a reference to the board, but when he was asked to sign an affidavit and swear under oath. He wanted to be completely sure of everything that he was saying, as an honorable man would do. And that's why those changes were made. And the affidavit you have got is something that he has read over and that he is absolutely sure about. And I apologize for the misunderstanding. Ms. Bam, no. I understand how people are more careful after they talk to a lawyer about what they say before. So I understand that. But he took out a couple of things. And one was, it's not unusual to be sued numerous times over an 8-year career. That's something that he didn't put in his second affidavit. And I think this is because he wasn't there, so he doesn't know. But he took out Mr. Morgan was completely truthful testifying under oath relating to everything involving the matter. I think, I assume that he took that out regarding the accident the judge asked you about. Is that why? And maybe, Mr. Graham, you can tell me that because he wasn't there, so it was difficult for him to swear that he was completely truthful testifying to that? Mr. Graham, ma'am, I don't want to step on thin ice, and I certainly don't want to be a witness in these proceedings. But, Ms. Bam, did you draft this affidavit? Mr. Graham, I did draft the affidavit, yes, ma'am. I sure did. Ms. Bam, I just noticed there are a lot of deletions, and I'm trying to get to. Mr. Graham, there certainly are, ma'am. Ms. Bam, do you know why these things are not in there? Mr. Graham, with respect, specifically with respect to the question you posed, he told me he did not hear Mr. Van Morgan testify, so he could not. Ms. Bam, so what I suggest is why that was taken out, right? Okay, all right. The show cause order says this. I am troubled by you not putting all of this. What happened to you? The termination on your application, for the bar. When I read it, I think whether, you were assuming something that you thought was wrong or they were pursuing something against you. It appears to be that even though it is not necessarily maybe as artfully worded as you want, that it is something you should have put on your application. So can you expand on that a little bit for me as to why that was not listed? Mr. Van Morgan, you're absolutely right. I should have put that on my application and put every one of the cases in there. That was a failure on my part. And the only thing I can say is that I did mitigate that as soon as I was notified and that I wasn't. I honestly wasn't trying to hide anything. I did have that on the application that I was terminated from the highway patrol, and that was on the application. So my thinking was that the NCP would pull that up and find those cases, and that's what I was thinking. I didn't think that would hide anything because it's court records. And I understand it's my responsibility, and I should have done better, and I didn't do right on that. And I apologize for that. But I would ask you to consider that I wasn't trying to hide anything because it's a court case, and I thought they would pull it up as about the only thing. Ms. Bam, it's obviously candor and honesty is very important to be a lawyer. I know you know everything you have gone through, law school and the bar exam. So what I am struggling with, I want you to know this. Personally, we haven't discussed this, that there is a judicial tribunal that has found that you are not credible in your testimony, and then you don't list lawsuits or, the type of things that I think are clearly supposed to be on the thing, on the application. So we kind of have two major infractions that we're looking at that indicates, okay, not only something that happened before you went to law school, but it's something that happened when you were filling out, to be a lawyer, filling out your bar application. And so that's why I keep asking you about this, because I was wanting to be reassured from you. Even though we have this, 6-year span, we have these two incidents, that you understand the importance of honesty and candor as a lawyer. The responsibility, even when it is not necessarily a good picture. You know what happened, even if you might not be reflected in the most positive light, because we as lawyers have to own up to our mistakes as we make them to the court and on our clients. It's a very important part of being in the profession. Mr. Van Morgan, right? And you're absolutely right. I'm not going to make any excuses other than I did report it. But I understand what you're saying. And it does absolutely look that way. And I apologize for that. I'll try to do better with that. It's hard for people to report bad things about themselves, but I apologize for that. And I thought that was part of the record that I will. The only thing I can tell you is, I will try to do better. The first thing about making a mistake, I think, is recognizing that you did it and trying to correct it. And also, I have taken the classes in ethics and tried to do the best I can to go forward. I'm asking you to let me do that. Questions by Mr. Barker. Q. Mr. Morgan, were there any tests done on the body of this young man that was driving the car after the fire? A. Yes, there was. Q. Do you know what those tests did or didn't show? A. They showed an extremely high alcohol level, 0.21, and also marijuana. Q. The reason I asked that, in your answer, you had said you were in pursuit of an intoxicated man. So that was established, that he was intoxicated, or at least blood alcohol level. A. Yes, it was. Mr. Barker, okay. Questions by Mr. Ward. Q. Mr. Morgan, time-wise, your termination was back in 2012? A. The termination from my job was in a long story. There was actually an investigation done by the Internal Affairs Department, where I sat in front of a sergeant and two sergeants and a captain over internal affairs when I was taken off duty and was questioned for about 2 hours about the incident. Q. Was that questioning that occurred under oath? A. It was. I was issued the Garrity warning, where I was notified that anything could be used against me. I don't specifically recall. Q. To be used against you for purposes of an employment context, but not in a criminal context, the Garrity warning? A. Right. And that's when I was taken off duty. And I was in civilian clothes. And I talked to them about the incident for about 2 hours. And immediately following the interview, they put me back to work. So then it was about 3 months later, on February the 20th, when I was initially terminated, yes. Q. February 20th, 2012? A. 2012, yes. Q. So then where's that in the process of when you applied to law school? Is it at the administrative level that you're contesting the termination? Where is it when you were applying to law school? A. I was actually in law school at the time. I was at Duncan School of Law. Q. You were at LMU at that point? A. Yes. And I notified them of the incident and told them what was going on. I actually conferred with my attorney. Attorney-client privilege is mine, that I conferred with my attorney, and he actually wrote me a draft of what to tell the law school, and I copied and pasted that draft and gave it to Duncan School of Law. It's pretty much the same thing that I sent to Nashville School of Law. Q. And then you're applying to Nashville School of Law when? A. I think I applied for them in November of 2012, and they accepted me, and I started law school in, I think it was, January of 2013. MS Sakala, Nashville School of Law. The witness, yes. By Mr. Ward. Q. So when you applied at Nashville School of Law, was it in the administrative phase? A. Yes. Q. Challenging the termination? A. Yes. It was in the stage. There had been no court hearing on it. Q. And what you reported to the Nashville School of Law was what? A. Was that I had been wrongfully terminated from the Highway Patrol, which is what I believed, and that the case was pending. Q. And so that was in 2012. And then you have the administrative procedure which goes against you, correct? A. Yes. Q. And that was appealed into Chancery Court? A. Yes. Q. Which again went against you? A. Yes. Q. And does that finish up while you were in law school? A. Yes. Q. Are you out of law school when that Chancery case finishes up? A. Well, okay. I think that the Chancery Court was after I was out of law school, pretty soon after I was out. And so I was already out of law school in the Chancery Court, in the administrative appeal. And then there was another appeal to the Tennessee Supreme Court after that, which was in 2017, and they denied hearing the case. Denied. I think it was in November of 2017. And that's when the case was final. Q. So what I'm looking at here, it suggested that the administrative proceeding was done in 2014 sometime. Does that sound right? A. Yes. Q. And that would have been while you were still in law school? A. Yes. Q. Did you have to update the law school with respect to the results of that? A. Did I have to? No. That obviously I should have, but I did not know. Q. So you didn't advise the law school of that finding at that time, but there was an appeal of that to Chancery Court? A. No. I did not. Q. I guess part of my concern is, the report to us is essentially the same report that you gave initially, that it was a wrongful termination and that you were appealing it. That's what you reported when you applied for your Tennessee license. A. Right. And that was the case at the time, right? Q. When you applied for your Tennessee license, you had already had an administrative proceeding that went against you, hadn't you? A. Yes. Q. Were they made some specific findings against you on a credibility basis? A. Yes. Q. And my concern is not only have you had credibility findings against you there, but those credibility findings weren't even reported to us. Like Ms. Bem, I have trouble understanding why that was not reported to us. A. Well, from my perspective, the case was still pending. And I don't believe that I have a credibility issue. You might find different. I'm telling you the truth. And I contested those findings with legal counsel. And what I put on the application, although, obviously, I agree with you, not sufficient, it was not anything to me personally being deceptive. But if you deem that inadequate and don't give me my law license, I'll have to live with that. But honestly, it was not intentional. I mean, I could have reported that the judge found that I wasn't credible. But if you look at the record, what I testified to, there was nothing in there that you can say, well, he said this, and look at that. So I don't feel like I'm incredible. Uncredible, I mean. Frankly, I can say, so and so is uncredible, and that's the legal ruling, and I understand you have to go with that. That's what he said. Well, if I can't say, he did this and then over here, he did that, so I know that he's lying, and there's nothing in that legal record that says, that can prove that I am lying, because I know that I'm not. So you're right, I did not report that, and I should have. But I'm just trying to explain why I didn't. Questions by Ms.
Zoccola.
Q, didn't you report it and say, this is what they found, but I have appealed it, or I disagree with this, to show that you thought that it was not final, or there was something else was going on? A, exactly. I should have. Q, that's what you should have done? A, right. I agree with that. And I mean, I'm not giving excuses. I was in law school. Q, you did report that it was happening though? You didn't totally leave it out? A, right. Questions by Mr. Ward. Q, Mr. Morgan, what I'm struggling with is, we as a board are faced with documentary records that have multiple people saying that they have had problems with you from a credibility standpoint. That's with reference to, I guess, Commissioner Gibbons that made an initial determination that your version relating to this event was not credible. Then you had a district attorney also say that you didn't have credibility and wouldn't present. I don't know whether it's 95 cases based upon that. And then we have had an administrative law judge make the same determination that was then appealed to Chancery Court, then upheld by the Court of Appeals, which puts this board in a position of having to basically say that you have the character and fitness to practice when all those credibility determinations have been made negative to you. From your standpoint, how would you have us justify that? Okay, let me answer this. Everyone did not determine that I had credibility issues. The commissioner you mentioned, the commissioner on the Department of Safety, he did not say that I had credibility issues. What he said was that I saw that wreck or should have saw it, and he said specifically that he did not know, that he could not say that. And I can tell you that, but I didn't. And what is being adjudicated that I have credibility issues on is based on me not seeing a wreck off the side of the road in the dark and surreptitiously recording. It is things that happened in 2012. And another district attorney during the same time, when I wasn't even employed, gave me a subpoena that I have given you all, and I met with him about testifying under oath in a vehicular homicide case. So obviously, he took the differing view. I was issued the subpoena by the Tennessee Highway Patrol. I met with the district attorney in Claiborne County, Jared Effler. This is when I didn't have a job. This is when I was struggling to survive, me and my wife. And I drove on my own without being paid and met with him about a case that he subpoenaed me on with the Highway Patrol, a sergeant trooper there, and discussed a pending vehicle homicide case that he asked me to go testify in Claiborne County. And even, Mr. Harbison is not here now, but I was in his class at the time, and I went to him. I said, they're subpoenaing me to testify in a vehicle homicide case on the day that I have a class, so I can't be here. And I remember Mr. Harbison saying, that's fine. You do what you need to do. That's okay. And so I went and met with them. And I was scheduled to testify in June of 2013. And he asked me to. And the day before that I was driving out there to testify under oath, he told me, just tell them what happened about the Highway Patrol. What he wanted me to testify to is, I drew blood at the hospital for a fatal accident, and he was wanting me to testify. And I did this quite often for troopers in another county that couldn't get to the hospital quick enough to draw blood. And this was a case involving where a man killed 2 people in an intoxicated driving wreck, and I drew the blood with a nurse present and packaged the evidence for something I took very seriously, and I documented it and turned it in to the evidence custodian. So he needed me to testify to the chain of evidence in a vehicle homicide case. And I was scheduled to testify. Again, I was subpoenaed, and the only reason why I didn't testify is not because of any credibility issues, is because the defendant pled guilty to the charges the day before, and I got a voicemail saying that, you're not needed to testify. I forget the defendant's name. He has pled guilty, so we don't need your testimony. And that was Mr. Jared Effler. So although the district attorney in Knox County said that, another district attorney said the same thing, that I was credible, and I hope that you find that I am. The way that I would answer to people that the court found me not credible, quite frankly, is to say that, you asked me, and I'm not telling you what to do, is to say that I have taken classes to improve my credibility. I am not arguing the findings of the court of law. I respect those. And they found what they found, and I respect that. And my job was gone because of that. That's fine. But I would ask you to say that I have taken classes to mitigate that and to try to be ethical, and that I have well-respected military veterans that testify to my credibility under oath with the affidavits, after having well thought out what they said, and a former supervisor. And as bad as that incident was, and it was horrific, I did not die that night. Someone else did, which is sad, but I didn't. What I did was, I continued going to law school, and I graduated from law school. And people make mistakes. Obviously, I made some mistakes, some errors, and wasn't perfect. There was no attempt to deceive or hide things. I could have done better. And if the standard is perfection, checking every box correct, then, I'm probably not going to get my law license. If the standard is going to be to honor and respect the court and to do the best, I can help apply to the board, which is what I intend to do. I was the son of a widow. My father died when I was about 2 years old. My dad wasn't the governor, and no one helped me. But I do respect the rule of law. I think that lawyers need to change a lot of things within the system, which is all I have ever tried to do. And I contested those cases within the system. And I would ask you to consider the totality of the record. And I'll defer to Attorney Graham. If you want to further, I appreciate him being here. He is also a military veteran, and I obviously have respect for that. Mr. Graham, sir, I can offer one comment that might help you. Mr. Ward, could you speak up for us? Mr. Graham, sorry. What I was saying here is, I would like to offer some information that might help you with respect to the credibility issue. It was at issue 3 times at the administrative proceedings, and then later on in the Chancery Court, and finally at the Court of Appeals. In each case, the credibility issue was the same thing. Did he in fact see the accident? So this is a reoccurring theme where it's being examined each time. The issue came down, and I think the record is clear in this matter. Mr. Van Morgan never denied seeing the wrecked car on the right side of the road. What he said, although apparently not very well, is that I did not recognize it as the car that I was chasing. I tell you quite candidly that no one agrees with that, and that is where the credibility issue is reoccurring. No one has said he is a liar. No one has said he's misrepresented the facts. What they're saying is, we don't believe you didn't see that car, or at very least you should have. MS Sakala, isn't that the same thing as misrepresenting the facts? We say you saw the car. You say you didn't see the car. We don't think you're telling the truth. That's what they're saying. Is that right? MR, Graham. In a manner of speaking, ma'am, you are correct. But I think at the risk of repeating myself, the issue is, they're saying, we don't believe either you saw it, or they've been very clear you should have seen it. MR, Barker, Mr. Morgan, what we're worried about is not so much the accident. It was a horrible accident. Apparently there was another accident where there was a high-speed chase and somebody died. That's not what we're here about today. What we're here about today is, we want to be able to say to the public when we give somebody a law license, we can depend on them to tell the truth, to the courts, to the other lawyers, to the clients. That's what we're concerned about. Can we say that? MR, Van Morgan, yes, you can. Absolutely, I will. I will do my very best to tell the truth and act honorably and responsibly. MR, Barker, that's all I have. Questions by Ms. Bem. Q, but the last lawsuit that was filed by the family, the Alito family, says it was voluntarily dismissed. But was there a settlement? A, no, there was nada. Q, no money? A, settlement, no. Q, no settlement. So it was dismissed a few months later? A, I filed an answer denying the accusations. Let me just say that, I have kids. That was a horrible thing, and I wish that it hadn't happened. So I hold no ill. But yeah, they voluntarily dismissed it. There was no settlement. Q, and I know there was a lot of media, so I know you also had to deal with that with your family too, of the comments you made about, the fire extinguisher. That's in the record. But I'm wondering, I'm looking in here, and I see that at one point you do say you are suspended. I mean, there are places where you definitely could have told us a whole lot more. But there is you. But you do say the reason for leaving and were wrongfully terminated pending the appeals court in Tennessee, Davidson County, on one answer. There is kind of an alert there. But then there were other places that are definitely needed to have said something about what was going on, about being discharged or being cited or disciplined or whatever, that there was not more information. So it's kind of difficult to know what to do about your application because it's incomplete, but there are signs there, but they're not complete, so. A, I assume. Q, it's hard to know what to do. A, I assume that you would find those court records based on the putting them in there. I wasn't trying to hide anything. MR, Ward, does the board have any other questions? MR, Barker, no. MR, Ward, any other witness you want to present at this point? MR, Graham, I have 4 small affidavits, sir, I would like to introduce. MR, Ward, I'm sorry. MR, Graham, I have 4 small affidavits I would like to introduce. I will be very brief. MR, Ward, absolutely. Are these ones that were previously introduced? MR, Graham, yes, sir. MR, Ward, if they are previously produced, they are already part of the record. You are welcome to reintroduce them if you want to. But if they have already been filed, they are in our record. MR, Graham, would you allow me just a brief explanation? MR, Ward, absolutely. MR, Graham, so the first one is Nolan Hatley, PhD. The significance of this is that Mr. Morgan attended training, ethical training. This affidavit concludes with a favorable examination, or a favorable recommendation to the board. The other 2 are supervisor, affidavits from his supervisors, the same thing. They describe his service as honest and credible, honest, respectful of the rights of others, adheres to the Constitution, and these sorts of things. Both of these affidavits conclude with favorable recommendations. The last one you have, I think you have seen this. This is a character reference similar in nature. That's all I want to present. MS Sakala, what is that one from? MR, Graham, this is Chris Sullivan, a karate instructor in Nashville. He is a personal friend of the applicant here. These witnesses couldn't be here because of distance. MR, Ward, and if you would like to hand those to the court reporter, we'll go ahead and mark those as well. MR, Graham, thank you. If that completes the presentation of your proof, what we would like to do is have you both step out. The board will deliberate. If we're able to reach a decision today, we'll bring you back in and let you know that. If we're not, we will take the matter under advisement. The documents were marked exhibits numbers 33 through 36. MR, Graham, thank you very much for your time. I appreciate your wisdom. Recess for deliberations. MR, Ward, Mr. Morgan, and Mr. Graham, the board has deliberated. At this point, we have not been able to reach a determination. What we're going to do is take the matter under advisement. We do have the materials you have submitted and the other materials that were previously submitted that we would like to read back through. And hopefully we'll be able to reach a decision in a week or so, and we'll issue an order related to that at that point. And you will receive that when it is issued. So we appreciate you being here today, and thank you for your presentation. And we'll have something for you soon. MR, Graham, thank you, sir. MR, Van Morgan, thank you. Proceedings concluded. End of transcript.